Let's go.
Judge Fleischer confirmed that he would give his conclusion within a couple of hours, ensuring that a final decision on the motion would be reached by the end of the day. The judge imposed that he would focus on the facts over the testimony because Officer Roher's verbal presentation in court was compromised, forcing the court to rely strictly on the objective, raw evidence recorded at the scene. Under the standard framework on State versus Ross, a trial judge acts as the absolute sole judge of witness credibility and the weight given to any testimony during a suppression hearing. Because of this, prosecution witnesses are expected to properly refresh their present recollection prior to testifying pursuant to Texas Rule of Evidence 612. Failing to thoroughly review offense reports risks exposing a fatal lack of independent memory on the stand, which undermines the state's burden of proof. After the hearing, Judge Fleischer On July 7, 2024, defendant Carlos Armando Alfaro was charged in Harris County Criminal Court in Houston, Texas, with driving while intoxicated as a second offense under Texas Penal Code Section 49.09a. The charge arose from an incident earlier that night when Officer John Johnson was dispatched to a location where Mr. Alfaro was accused of operating a motor vehicle in a public place while impaired after being discovered asleep at the wheel of a vehicle that was stationary but remained running in an active lane of traffic. Defense attorney Jose A. Seja challenged the lawfulness of the arrest by filing a motion to suppress evidence, asserting that the officer did not conduct standardized field sobriety tests at the scene. Mr. Seja argued that this omission meant the officer lacked probable cause to effectuate a warrantless arrest, constituting a constitutional breach under the Fourth Amendment's protection against unreasonable seizures. In Article 38.23 of the Texas Code of Criminal Procedure, to justify the initial investigatory detention, the state relied on Texas Transportation Code, Section 545.302, contending that by remaining completely stationary inside an active travel lane, Mr. Alfaro committed a traffic violation by illegally stopping or standing a vehicle in a prohibited section of the roadway, establishing reasonable suspicion for the officer to make contact. On April 1, 2025, a dispositive hearing on the motion to suppress was held before Judge David Fleischer. A dispositive hearing is a legal proceeding concerning a motion that will directly determine the final outcome of the case. If the court rules in favor of the defense and suppresses the evidence, the state is left without the necessary proof to proceed, effectively forcing a dismissal of the charges. On the other hand, if the court rules in favor of the state, the challenged evidence is deemed admissible, allowing the prosecution's case to move forward toward a trial or a plea agreement. The state called Officer Johnson as its first witness. After the state concluded its direct examination, Mr. Seja began his cross-examination.
So can you describe in general your role in this investigation?
I was the first officer on scene, and I was one of the dispatch and responding officers to it.
Okay, and fair to say that he was in pretty deep sleep, right?
Sure.
And at the scene, very little time was spent with Mr. Alfaro. Is that right?
Yes.
Okay. Now, you said that you've done approximately 5 DWI investigations?
Yes, but that's what it was. Yes.
Okay, but you've done your NHTSA training,
Yes.
and you know that the second stage of the NHTSA training is called the personal contact stage, right?
Mm-hmm.
Do you recall what that is?
Yeah.
Okay. You know that in any investigation, it's important to spend time with the person that you're investigating and try to distinguish illegal from legal behavior, right?
Absolutely.
And in kind of big picture terms, that's one of the things that the NHTSA manual teaches you how to do, right?
Mm-hmm.
Is that yes?
Yes.
Because it's not illegal to drink and drive. It's only illegal to drink and drive while you're intoxicated, right?
I'm not necessarily. I mean, there's I'm on belt and detainer and other violations as well.
Well, we can agree that in not all.
About DWI, then yes, I would agree with you.
Okay. In general, not every time that somebody drinks after having consumed alcohol, not every time are they committing a crime, right?
Correct.
Okay. Now, in this case, you were dealing with somebody who was deep asleep and was roused out of sleep, right? And it wouldn't be surprising if that person exhibited things like red eyes, right?
Yes.
Yes, it would not be surprising.
It would not be surprising.
Okay. That they appeared maybe a little bit disoriented, right? And you say that his speech was slurred, but you had never met Mr. Alfaro before, so you don't know how he normally talks, right?
Yes, sir.
Okay.
I know what slurred speech sounds like.
Okay, but would it surprise you that especially on the station where the audio is more clear, his speech doesn't appear slurred at all?
That would surprise me.
All right. So in the time that you spent with Mr. Alfaro at the scene, that wasn't enough to distinguish whether the symptoms were from alcohol intoxication, possible alcohol intoxication, or just being roused out of a deep sleep, right?
I will not know. That's why I'm arrested for DWI right there.
I understand that, but in general, after such a brief amount of time, that wouldn't necessarily be enough to convince yourself that this is just a person that I've woken out of a deep sleep, right?
With other factors, I would disagree, but I mean, there's a possibility.
All right. Did you write an offense report in this case?
I wrote the supplement report.
Okay. Your offense report actually doesn't say anything about arresting him for impeding a roadway, does it?
My supplement does.
And Officer Rohrer, who was the lead officer in this case?
Officer Orr was the one that worked the DWI investigation.
Okay, and it was his understanding that the scene was being moved to the scene to continue the DWI investigation. Is that right?
Objection, Your Honor, speculation.
If you know.
I don't know what Officer Rohr put in his report, but I'm not going to tell you what was in his report.
During cross-examination, Officer Johnson confirmed the legal distinction that it is not inherently illegal to drink and drive, but rather it is only illegal to operate a motor vehicle while intoxicated. Under Texas Penal Code, Section 49.01(2), intoxicated is defined as either not having the normal use of mental or physical faculties by reason of the introduction of alcohol or drugs, or having a blood alcohol concentration of 0.08 or higher. Mr. Seja argued that the officer's on-scene handling of the encounter lacked reasonable investigation and due diligence, emphasizing that Officer Johnson spent a minimal amount of time conducting a field investigation and rapidly escalated the encounter from a routine traffic contact or welfare check directly to a custodial DWI arrest and station transport without establishing sufficient probable cause. Under standard National Highway Traffic Safety Administration, known as NHTSA, a police officer's investigation should involve adequate time during the personal contact phase to evaluate clues and rule out innocent alternative explanations, such as a driver exhibiting red eyes and disorientation simply from being suddenly awakened from a deep sleep. Since Officer Johnson had done only approximately 5 DWI investigations throughout his career, Mr. Seja's approach seems to undermine the officer's level of preparedness and competence for the alleged misdemeanor, demonstrating how a lack of field experience can lead to a rushed and unreliable legal assessment. After Officer Johnson was excused, the state called Officer Brian Rohrer, a designated specialized DWI investigator, to the stand, to whom Officer Johnson had turned over custody of Mr. Alfaro at the processing center.
Do you remember, do you recall the incident that we're here for today that occurred on July 7th, 2024?
Yes, I would.
And can you explain how you became involved with that?
With a call service, officers went out, found the reason was people stopped in a roadway. They had reasonable conceit to believe a DWI investigation needed to take place. I couldn't make it out to the scene, so the subject was actually transported up to our in-top room to me.
And upon contact with the defendant, what did you notice?
I noticed eyes were red, also detected odor of alcoholic beverages and some slurred speech.
And what did you do next?
Next was going into the other DWI investigation, which would be Miranda's questioning and then sobriety tests.
Do you recall the specifics of your investigation as far as the center responsibility test?
As far as the specifics in clues specifically for the assessee.
Generally, yes. If I were to ask you about the clues that he exhibited, would you recall that?
I would probably have to reference the report again.
You made contact with the defendant and you began to carry out your investigation. What was the first step in that process?
So the. Excuse me, I'm sorry. First step of the process would be an interview of the site.
And what did you learn from that interview? Okay, we're going to skip that. We're going to go to the standardized field sobriety test. What was the first standardized field sobriety test you carried out?
Horizontal gaze nystagmus test.
Okay, and what is that test?
That test checks for the involuntary jerking of the eyes.
And what were the results of that test?
The result on that were 6 out of 6 validated groups.
What are those 6 clues?
The first one is a lack of smooth pursuit. Then following that is a distinct and sustained nystagmus, maximum deviation, and then the onset of nystagmus prior to 45 degrees.
And it's fair to say that he hit all 6 of those clues.
That is correct.
And what does that indicate to you?
That would indicate the presence of a substance in this system.
Would that indicate alcohol, potential presence of alcohol in the defendant's system?
Yes.
And what did you do next?
Next was the walk and turn test.
Okay. And what is the walking train test?
The walk and turn test is one of the psychophysical tests, where it splits the subject's mental and physical capabilities to obviously a intoxicated individual would have difficulty splitting those.
And what were the results of this test that you did?
On this test, I observed 2 out of 8 validated groups.
And what did you do next?
Next was the one-leg stand test.
Great. And what is the one-leg stand test?
Again, it's another psychophysical test. Testing the subject's ability to count while balancing on one leg.
And what were the results of this test?
On this test, I observed 0 of 4 validated groups.
And what did you do after that?
After that would be reading the subject EIC 24.
Based on the totality of the circumstances, were you able to form an opinion on whether or not the defendant was intoxicated?
Based on the totality of circumstances and the results of my investigation, I did form an opinion that he was intoxicated and had lost the mental and physical capabilities required to safely operate a motor.
On direct examination, Officer Rower testified that Mr. Alfaro demonstrated 2 out of 8 standardized clues on the walk and turn test under NHTSA protocols. According to the NHTSA, when a person exhibits these standardized clues, it signifies measurable intoxication. Under the horizontal gaze nystagmus, a person who is impaired by alcohol will display distinct, uncontrollable eye tremors. In this case, the officer testified that Mr. Alfaro exhibited a maximum score of 6 out of 6 clues, which under Texas Rule of Evidence 702 is recognized as reliable scientific evidence of central nervous system depression. Officer Rower also stated that he needed to refresh his memory using his offense report, while legally permissible to help a witness remember exact details from a past event. This immediate reliance on documentation can directly damage the officer's credibility itself, as it risks being perceived by the court as a fundamental lack of case preparedness.
Good morning, I should say. You wrote in your report that Mr. Alfaro was transported to the Pasadena jail for further investigation after he was detained at the scene. Is that right?
That is correct.
Okay, so it was your understanding that he was transported to continue the EWI investigation, correct?
That would be my part of the investigation, yes, sir.
Okay, he wasn't under arrest for anything else as far as you were aware of?
As far as I know, when he was transported, he was placed under arrest for traffic offense.
All right. Now, you mentioned that it takes 2 to 3 hours to complete a DWI investigation. Can you break down exactly what goes into that?
So in those 2 to 3 hours in that estimation, I would be including initial contact of the subject, interview, observation, or possible interview of initiating officer, my interview of the subject, the SFSTs, as well as the collection of a forensic specimen and typing the report.
Okay, but really, when you're talking about an arrest, the relevant portion is usually much shorter than that, right?
That is correct.
So you're talking about maybe the personal contact stage and then the pre-arrest screening stage, right?
I'm sorry, I don't understand the question.
Well, I mean, the point at which you get enough evidence to confirm that somebody's intoxicated or disconfirm that somebody's intoxicated is much, much shorter than 2 to 3 hours, right?
Yes,
Because that takes into account booking procedures and things like that, right?
correct.
Okay. Now, this wasn't a situation where there was an emergency going on, right?
No,
Okay. Even though you're the more experienced officer, Officer Johnson is actually certified to administer field sobriety tests and has done so in the past, correct?
that is correct.
Okay. There wasn't a language barrier or anything like that, right?
Not to my knowledge.
And in fact, the intersection where this all happened, I mean, there were parking lots, drugstore parking lots, places where DWI investigations are sometimes conducted, right?
Yes,
Okay. So, in other words, there was nothing to stop the DWI investigation from being conducted where it was there at the scene of the incident. Nothing that you can point to, is there?
as far as the performance of SFSTs, no.
So what was the reason for moving this investigation to the jail?
To bring him to a member of our DWI task force who is better suited to performance of the SFSTs and to provide a space more conducive to performance of the SFSTs.
Okay, but if you had wanted to, it could have been this, or if, not you personally, but if law enforcement in this case had wanted to, this investigation could have been pursued more diligently.
Objection, Your Honor, speculation.
If there's a lot of sufficient space in a safe place, that again has sufficient space and level ground to perform the SFSTs, i.e. a space and level service more conducive to performing the SFSTs safely, then yes, it can be.
So it could have been done more diligently, correct?
It could have been possibly performed by the officer on scene.
Okay. Pass the witness.
Officer, approximately how long did this investigation take you?
This investigation, in terms of interview and arriving at a decision of intoxication, I would say approximately 40 minutes.
And typically, are DWI investigations faster or slower if you or another member of the DWI task force conducts the investigation, rather than a member of patrol unit?
It is significantly faster.
Mr. Seja questions Officer Rower about the officer's conduct on the scene of the initial traffic stop. Under the landmark U.S. Supreme Court decision in Dunaway v. New York, involuntarily transporting a suspect from the scene of a temporary investigative detention to a police station or processing facility transforms the stop into a de facto custodial arrest. Consequently, law enforcement cannot lawfully transport a driver to a police facility simply to continue gathering evidence. Officers must possess fully established probable cause for the offense prior to effectuating the transport. Furthermore, Florida v. Royer dictates that an investigative stop must employ the least intrusive means reasonably available to confirm or dispel officer suspicion. Under this standard, moving a suspect to a secondary location when an on-scene evaluation could safely be conducted exceeds the permissible scope and duration of the stop, rendering a forced jailhouse transport for a driving while intoxicated investigation unconstitutional. In this case, the officers relocated Mr. Alfaro to the jail before establishing clear roadside evidence of impairment, violating Fourth Amendment protections against unreasonable seizures. Under standardized field sobriety test protocols, a police officer must perform the physical sobriety investigation on the scene whenever environmental conditions safely allow. Officer Rower's own testimony conceded that Officer Johnson was certified to do the test, and a flat drugstore parking lot was readily available, meaning the criteria for a proper on-scene evaluation were fully met. Since there was no emergency on the streets to justify an immediate evacuation, Mr. Seja's cross-examination strategy directly exposes the lack of diligence in the police investigation. After that, Officer Rower was excused from the stand, and Judge Fleischer was ready for the arguments.
Argument.
Thank you, Your Honor. Your Honor, the state offers three arguments here. First is that clearly under the traffic code, Officer Johnson had probable cause to arrest the defendant at the scene for the traffic violation. Upon arrival, the officer could clearly see that the defendant was parked in a moving lane of traffic in violation of traffic code section 545-363 and 545.302. That arrest is clearly authorized under traffic code section 543.001. And after that arrest, once the officer had transported the defendant, then a separate DWI investigation took place, which is clearly legal and proper and does not violate any of the defendant's Fourth Amendment rights. And the alternative, Your Honor, the state would also show that the officer articulated sufficient facts to rise to at least reasonable suspicion that the offense of driving while intoxicated had occurred. The defendant displayed a strong argument about alcoholic beverages, was asleep in his vehicle, and took significant effort to wake up from the officers. Also, the time of night was indicative, and the other facts that the officer suggested, such as slurred speech and the other surrounding circumstances. Furthermore, moving the investigation to the police station and subsequent time it took to move the investigation. Furthermore, moving the investigation to the police station and the subsequent time it took to move the investigation was reasonable under the circumstances and served a legitimate law enforcement purpose. That purpose was to give the DWI investigation to an officer that would be more efficient at running the investigation. This purpose, this is supported by prior case law in Belcher v. State, where, Your Honor, the Court of Appeals out of Fort Worth found that a 30 to 35 minute prolongment was reasonable under the circumstances for the express purpose of the officer handing the DWI investigation over to a specific DWI officer for the purpose of efficiency. Furthermore, Your Honor, the state in the alternative to that argument would also go to show that probable cause existed at the scene due to the totality of the circumstances and the signs of intoxication and the clear operational facts that the officer had at the scene rose to the level of probable cause for the officer to arrest the defendant for the crime, for the offense of driving while intoxicated.
All right. Can you come up real quick, Blaze? Come up, Mr. Devil, come up. Sure, on the record. Okay. As a lawyer, as a person who just works in general, I really take pride in what we do. You know, when we do stuff, we come prepared. This is not a joke, man. This dude that just came and testified now was a deer in headlights when you asked about the just the interview, completely and wholly unprepared in every single way. So I don't give any credence to that testimony right there whatsoever. I mean, it's like, how are you going to come? This is not a joke. You know, we take this completely serious. You know, you come here, you can't even recite what happened. You can't even take 5 minutes to look at the damn report. You know, really. So that, no credence whatsoever. So what I'm going to do now is I'll take a look at the facts surrounding what happened on the scene, and I'm going to make a decision and see whether we go forward or not. But I'm floored how you're just going to come in and just kind of, here, let me just, you know, really, it's not a joke. It's a life on the line here. And I really take it seriously, and I'm just offended by it. So anyway, I don't need it.
All right.
Let me just take a look. I want to see that real quick, and then I'll have a decision here within a couple hours. Okay?
All right.
All right.
Thank you, Judge.
Thanks.
May we be excused?
Please.
Right.
All right, lawyers, let's go.
Judge Fleischer confirmed that he would give his conclusion within a couple of hours, ensuring that a final decision on the motion would be reached by the end of the day. The judge imposed that he would focus on the facts over the testimony because Officer Roher's verbal presentation in court was compromised, forcing the court to rely strictly on the objective, raw evidence recorded at the scene. Under the standard framework on State versus Ross, a trial judge acts as the absolute sole judge of witness credibility and the weight given to any testimony during a suppression hearing. Because of this, prosecution witnesses are expected to properly refresh their present recollection prior to testifying pursuant to Texas Rule of Evidence 612. Failing to thoroughly review offense reports risks exposing a fatal lack of independent memory on the stand, which undermines the state's burden of proof. After the hearing, Judge Fleischer granted the motion to suppress, and because this was a dispositive hearing, the ruling stripped the state of its evidence, and the case was dismissed. This case reminds us of the critical importance of the specific facts in a case, and the necessity for law enforcement to strictly adhere to proper constitutional procedures and investigative protocols. In criminal defense, the state's case relies entirely on the constitutional integrity of the initial police contact, detention, and subsequent arrest. During the cross-examination, Mr. Seja exposed Officer Johnson and Officer Roher's lack of due diligence and examination. Through questioning, the defense highlighted that Officer Johnson completely bypassed standardized field sobriety tests at the scene, despite having the opportunity and tools readily available to conduct them. Furthermore, the cross-examination of Officer Roher revealed a profound lack of basic case preparation, culminating in the judge explicitly dismissing his testimony due to his inability to recall or substantiate the foundational details of the encounter. When officers don't do a proper investigation, they risk transforming a standard investigative detention into an unconstitutional de facto arrest. And by taking shortcuts, law enforcement commits a fatal procedural error. Ultimately, when police conduct falls short of these legal requirements, it results in a direct breach of the Fourth Amendment's protection against unreasonable seizures, leaving the court with no choice but to suppress the unlawfully obtained evidence and effectively forcing a dismissal of the entire case.